Hearing in the appeal, Chandler against the statement.
Mr. Fitzgerald.
Yes. My Lords and my Lady, I appear with my learned friends, Mr. Douglas Mendes of Senior Counsel, who appears remotely, my learned friend, Mr. Rajiv Prasad, and Miss Amanda Cliff-Matthews for the appellant. The Attorney General of Trinidad is represented by my learned friends Howard Stevens, Queen's Counsel, Tom Poole of Queen's Counsel, Fayed Hussain, Senior Counsel, and Hannah Fry. My Lords, before handing the baton over to my learned friend Mr. Douglas Mendes, can I just make some short remarks? This is an appeal, as the Court will know, against sentence of death. The permission to appeal was granted in the light of the ruling of the Caribbean Court of Justice in the case of Nervais and other developments. The ruling of the Caribbean Court of Justice in Nervais was on the 27th of June 2018, and the Caribbean Court of Justice gave that ruling in its capacity as the final court of appeal for Barbados. And in that judgment, the Caribbean Court of Justice declined to follow the decision of the Privy Council in Boyce in 2004, and it further declined to follow the reasoning of the majority of the board in that case, that the General Savings Clause in Section 26 of the Barbadian Constitution prevented the court from modifying the existing law so as to render the death penalty discretionary rather than mandatory. My Lord, just starting with the decision in 2004, the earlier ruling of the board in 2004 was by a narrow majority of 5 votes to 4, and the ruling that there was no remedy was made despite the general acceptance recorded in paragraph 12 of the judgment of Lord Hoffman that the mandatory imposition of the death penalty was a cruel and unusual punishment. It was a cruel and unusual punishment because it imposed the death penalty on everybody convicted of murder, irrespective of the circumstances of their offence and their individual mitigation. Lord Bingham in Rays put the injustice in this way, that's at paragraph 43 of Rays, to deny the offender the opportunity, before sentence is passed, to seek to persuade the court that in all the circumstances to condemn him to death would be disproportionate and inappropriate, is to treat him as no human being should be treated, and thus to deny his basic humanity. And that was the core of the right under Section 7 of the Belize Constitution, which is the equivalent of 5.2b of the Trinidad Constitution. The effect of the ruling in Matthews was that the court was powerless under the Constitution to remedy this admitted injustice because the Savings Clause protected all existing laws from challenge for inconsistency with Sections 4 or 5 of the Trinidad Constitution. My Lord, in its judgment in the case of Nervais, the Caribbean Court of Justice endorsed the interpretative approach of the dissenting judgment of Lord Bingham and the minority in the Bayesian case of Boyce and in the Trinidadian case of Matthew. The minority had found that the existing law's savings clause in the Barbadian and Trinidadian Constitution did not prevent the modification of the relevant statutory provisions, and the effect of that modification was to impose a discretion rather than obligation to impose the death penalty. So just drawing back for one moment, there is no dispute that the mandatory death penalty constitutes a cruel and unusual punishment. There is no dispute, and indeed there is ample precedent for the fact that if the power of modification is available, it can be modified. The words shall suffer death can be modified to may suffer death. There's no dispute on those two matters. The only third matter on this first ground is whether the existing law's savings provision in Section 6.1 of the Trinidad Constitution prevents the court from modifying in the way it has modified in many other Caribbean jurisdictions, Belize, throughout the Eastern Caribbean, Bahamas, Jamaica in the Lambert and Watson case. Our respectful submission to the Board is that developments in the Caribbean Court of Justice, and indeed in the Inter-American Court, now justify the Board in reviewing and reversing the decision of the Board in Matthew in 2004. The effect of reversing Matthew would be to bring the practice in Trinidad into harmony with that of the rest of the Commonwealth Caribbean. Throughout the rest of the Commonwealth Caribbean now, a regime of discretionary capital sentencing operates in the cases of those convicted of murder. I've given you the jurisdictions. Belize first in Rays, the Eastern Caribbean in Hughes and Fox, Bahamas in Bow, Jamaica in the Watson case, and now, as a result of the decision in Nervez, Barbados. So throughout the rest of the Commonwealth Caribbean, the position is that it is now discretionary rather than mandatory, because similar provisions, similar statutory provisions, have been modified by the constitutional remedy of modification so that shall suffer death or shall be punished by death is removed, and maybe sentenced to death is substituted. With the Board's leave, my learned friend, Mr. Douglas Mendes of Senior Counsel, who argued the Nervez and McEwen cases, will first deal with our ground one. And ground one, as set out in the SFI at page 260, is that the savings clause in section 6 of the Trinidadian Constitution does not prevent a court modifying the provisions of section 4 of the Offences Against the Person Act so as to replace the mandatory death penalty with a discretionary death penalty. And then, my Lord, again, with the Court's permission, I will deal with any additional points on ground one and with ground two. Ground two is that the mandatory death penalty violates the separation of powers and the rule of law principle, and we derive support from the fact that the judges of the Caribbean Court of Justice unanimously found a breach of the principle of separation of powers in the imposition of the mandatory death penalty. And obviously I'll also deal with the issue of the rule of law, which we derive from Koirati, and which we derive also from the cases of Nervez and McEwen. My Lord, that's just a very brief introduction, and then if I can now hand
yes, by all means,
the Court to my learned friend, Mr. Mendes.
Thank you, Mr. Fitzgerald. Mr. Mendes.
Thank you very much, my Lord, and thank you very much to my learned friend, Mr. Fitzgerald, for that introduction. Our case is that because Section 4 of the Offences Against the Persons Act is out of conformity with the Constitution, that the Supreme Court must comply with Section 5(1) of the Constitution Act and to construe Section 4 with the necessary modifications to make it conform. Now, our case is that the power of modification under Section 5 can only be exercised where the existing law, which is under challenge, does not conform with the Constitution. We do not say, as the respondents seem to suggest in their written submissions, that an existing law which already conforms with the Constitution can be modified under Section 5. That is not our case. And indeed, it is apparent from the terms of Section 5 of the Constitution Act that you can only exercise the power of modification where the existing law does not conform with the Constitution. My Lords, my Lady, you will see Section 5 of the Constitution Act at the electronic bundle, page 416, where it provides that, just reading the latter part of it, the existing laws shall be construed with such modifications, adaptations, qualifications, and exceptions as may be necessary to bring them into conformity with the Constitution, which of course presumes that the existing law is not in conformity and needs to be brought into conformity. We therefore agree with the respondent's submission, which you will find at electronic bundle 363, at their paragraph 90, and I quote, "The first question to be answered is whether the existing law is or is not in conformity with the Constitution. If it is in conformity, no question arises of modifying it under Section 5.1. Learned friends, for the respondent suggests at their paragraph 92, which is electronic bundle 364, that somehow in our submissions we have skipped that step. But of course, it's quite apparent that we did not skip that step because we spend quite a bit of time saying in what ways Section 4 is not in conformity with the Constitution. And of course, it is agreed, as my friend Mr. Fitzgerald just pointed out, that Section 4 is inconsistent at the very least with the prohibition against cruel and unusual treatment or punishment. Now, it is the respondent's case that Section 6.1 of the Constitution, that is the Savings Law Clause, renders all existing law in conformity with Section 4 and 5 of the Constitution, and that accordingly there is no room for the exercise of the modification power under Section 5. And you will see that in their case, at electronic bundle, page number 339, at their paragraph 6. In the last 4 lines of that paragraph, they say the respondent submits that the effect of Section 6 of the Constitution is to render the mandatory death penalty in conformity with the Constitution. This being so, notwithstanding the fact, as was held in Boyce and Matthew, that it infringes Section 5.2b of the Constitution when read in isolation. And you will see that they repeat that submission at electronic bundle page number 359 at their paragraphs 76 and 77. And then again at page number 363 at their paragraph 88. So that the entire premise of their submission is that the effect of Section 6 is that the mandatory death penalty conforms with the Constitution. In fact, this is the approach which the minority of your Lordship's board in Rudall had taken. And if I can just take you briefly to that decision, it's at electronic bundle page 744 at paragraph 80 and 82 of the judgment of Lord Roger and Millet. And at page 744, which is page 363 of the report, this is what they say in the last 4 lines of paragraph 80. Equally under Section 6.1a, no legal proposition an existing statute is to be void by reason of being inconsistent with Sections 4 and 5 of the Constitution. Illegal proposition or enactment which is not void by reason of inconsistency with the Constitution is valid so far as the Constitution is concerned. Then in paragraph 82, just at letter D, they continue, therefore nothing in Section 4 or 5 is to make the enactment or legal proposition in Section 4 of the Offences Against the Person Act void under the Constitution. So that enactment or legal proposition is valid under, and then this is the important point, and conforms to the Constitution. So that they equate, as my learned friends do for the respondent in this case, the absence of voidness or the inability to invalidate with conformity.
Mr. Mendes, could I ask you to pause for just one moment? I don't know if you can hear, but I'm hearing an echo.
Yes.
And I'm just wondering, it's not coming from somebody's laptop? I was just wondering if perhaps the sound was being fed through somebody's laptop. But if you have the sound off on your laptops, then no. Yes, it seems to be coming from this side of the room. Yeah. No, well, if it can't be helped, it can't be helped. I mean, we can hear Mr. Mendes perfectly well. It's just slightly distracting having the echo.
We're getting the sound, you need to have a look at the TV.
Right. Right. Okay. We'll resume and see if it works better. Yes, Mr. Mendes, when you're ready.
Much obliged to my lord. The point that I was about to make was that in Matthew itself, Lord Hoffman, for the majority, in the judgment in Matthew at least, does not say that Section 6 has the effect of making the mandatory death penalty conform with the Constitution. You will see the relevant paragraphs at electronic bundle page 551, and it's paragraphs 18 to 20. And if you'll bear with me, so I can read those paragraphs very quickly to you. Paragraph 18, he says, a reading of the Constitution without reference to the 1976 Act leaves no doubt that Section 4 and 5 are not intended to have any effect on existing laws. The only way in which the Constitution provides for those sections to affect any laws is by its express provision for the invalidity of any laws inconsistent with them, by the provision of such laws being void to the extent of the inconsistency in Section 2, and the provision in Section 5.1 that no law may abrogate the declared rights and freedoms, and the provision in Section 5.1 that Parliament, 5.2 that Parliament may not do the specified act. This is the language of invalidity. When Section 6.1 provides that nothing in Sections 4 and 5 shall invalidate an existing law, it precisely mirrors the effect which Sections 2, 4, and 5 would otherwise have. Then their lordships see no significance in the change of language from shall not apply to shall not invalidate. If there was any deep purpose in this change, a reader of the Constitution would find it remarkably obscure. The effect is exactly the same. If some reason is required, it probably lies in the language and declaration of the of supremacy in Section 2, void to the extent of consistency, which was new to the 1976 Constitution, and which the draftsman thought it convenient to mirror with the words, nothing shall invalidate. Then he goes on to say, if the Constitution itself shows a plain intention to preserve existing laws, the lordships find it impossible to accept that Parliament, by enacting Section 5.1, can have created a mechanism outside the Constitution for undermining the effect of its provisions. So he does not say in terms that Section 6 has the effect of making existing law conform, although he does say that there's no significance in the change of language from shall not apply to shall not invalidate. And of course, I'm coming later on in my submission to examine exactly what is the difference between those two formulations. But it does appear, however, from his judgment in the accompanying case of Boyce, that is a Barbadian case, that he does, that lingering behind his judgment is the notion that Section 6 in fact has the effect of making existing law conform. And you'll see that at electronic bundle pages 523 to 524, or paragraphs 51 and 52 of his judgment in Boyce, where in paragraph 51 he is responding to the submission of Mr. Starmer on behalf of Boyce in that case. And paragraph 51, he says, Article 4.1, which is the equivalent which is the modification clause in Barbados, requires any modification to existing law to be necessary to bring them into conformity with the Barbados Independence Act and the order. Part of the order with which Section 4 of the 1994 Act is said to be in conformity is Section 15.1 of the Constitution. But this submission of lack of conformity requires one temporarily to avert one's eyes from Section 26, which makes it clear that there is no possibility of lack of conformity between existing law and Section 5.1. Of course, the Section 26 that Lord Hoffman is referring to there is the provision that says that nothing in the existing law shall be held to be inconsistent with the Constitution. He says if the power modification is to apply, there must be lack of conformity not just with one section of the Constitution, but with the Constitution as a whole. So the view that he's expressing there, insofar as the Barbadian Savings Law Clause is concerned, is that its effect is that existing law is not out of conformity, that there is no lack of conformity. And if I can just ask you to jump to paragraph 52, where he says, their lordships do not accept these refined linguistic distinctions. Section 26 has the side note saving of existing law, and Section 3.1 of the 1962 Trinidad and Tobago Constitution has the side note saving as to certain laws. Likewise, the 1976 Trinidad and Tobago Constitution includes Section 6.1 under the heading Exceptions for Existing Law and gives it the side note savings for existing law. All three constitutions were intended to have an effect which can be described in various ways, all of which come to the same thing. In the past, the board has been inclined to regard them as creating an irrebuttable presumption that the existing laws were in accordance with the fundamental rights protected by the Constitution, and he cites the Freitas and Benny. The way of putting the matter is to say that they make existing laws immune from any form of challenge by reference to sections 12 to 23, but that immunity is complete. So it does appear, as I say, that the working assumption is that Section 6 has the effect of making the existing law conform. And you will see indeed in the later case of Johnson by your lordships, this is at electronic bundle 2874 at paragraph 13. Lord Roger, who wrote the opinion in that case, says the effect of Section 6.1 is that an existing law is not to be invalidated by Section 4 of the Constitution and is not to be regarded as inconsistent with the Constitution by reason of anything in Section 4. To put the point another way, Section 6.1 makes an existing law constitutional, that is, consistent with the Constitution, even though it would conflict with Section 4 if that section applied to it. So again, the working assumption is that this is the effect of Section 64. It means the same thing as Section 3 of the 1962 Constitution, which said that the fundamental rights provisions did not apply to existing law. And it means that the existing law is consistent with the Constitution. Now, of course, the effect of that is to create the very curious situation that even though the board accepted that the mandatory death penalty is a cruel and unusual punishment, that the effect of Section 6 is that it is a punishment which is not cruel and unusual, or if the existing law, as in Johnson, provides that married women but not married men are to retire from the public service, that is not a law which denies equality before the law. If you have a law that prohibits all opposition politicians from criticizing the government, that is not a law which infringes the free expression and the freedom to express political views, which is otherwise provided for under the Constitution. We respectfully submit that that is a overly generous interpretation of Section 6 of the Constitution and is not permissible under the normal canons of construction of provisions like Section 6, which derogate from fundamental rights and freedoms. Our case is that the Section 5 of the Constitution Act, that's the modification clause, Section 6 of the Constitution, Savings Law Clause, will proceed on the assumption that existing law would have been passed prior to the constitutions in 1962 and 1976 in accordance with the constitutional requirements for the passing of a valid law. So that the assumption is the law would have been passed by the colonial legislature in accordance with the manner and form requirements in existence at that point in time, so that it was a valid law in that sense. What Section 6 says is that nothing in Sections 4 and 5 shall invalidate that law. And what that means, therefore, is that despite section 4 and 5, the existing law remains valid. Its pre-existing validity is not changed. But it leaves unaffected, respectfully submit, the fact that the existing law may be inconsistent with section 4 and 5. So the only way we respectfully submit to read section 6 is that even though the existing law may be inconsistent with section 4 and 5, its validity as an existing law remains unaffected. But what is not changed is the fact that the existing law is inconsistent with the Constitution. So you have the situation where the existing law is, as the section 4 of the Offences Against the Person Act, in violation of a provision of the Constitution, but section 6 says that it cannot be invalidated. Now, the effect of section 3 of the 1962 Constitution is entirely different. It says, and you will see it at electronic page bundle 411, it says that sections 1 and 2 of the Constitution shall not apply in relation to any law that is in force in Trinidad and Tobago at the commencement of the Constitution. Now, when you provide that the human rights provision do not apply to existing law, it has the effect that the validity of the existing law cannot be challenged on the ground that they infringe fundamental rights and freedoms. It will not be possible at all to say that existing law is inconsistent with the fundamental rights provisions because the fundamental rights provisions do not apply to existing law. So in that sense, it would be quite possible to say that existing law conforms with the Constitution on the assumption that it doesn't infringe any other provision of the Constitution. You can say that existing law conforms with the Constitution because there are no fundamental rights provisions by which to judge its validity. That is the effect of a provision that says that existing law shall not apply. Existing law is therefore presumed to conform to the Constitution. Now, the respondent, however, says that nothing can be made of the fact that the shall not apply formula is not replicated in section 6.1. They say that the explanation for the wording reflects the fact that the Constitution now contains a supreme law clause. That is to say, it now contains section 2, which provides that any law that is inconsistent with the Constitution is void to the extent of the inconsistency. They say that the change in wording is necessary in order to counteract the effect of section 2. We've seen that I just read that passage from Lord Hoffman's judgment in Matthew at electronic bundle page 551 at paragraph 19. You will see the respondent's case on this point at electronic bundle 360 to 361 at their paragraph 82. If I can just read very briefly what they say. They say, starting from electronic bundle page 360, the last 3 lines of the last paragraph. They say the Constitution of 1962 contained no statement of the consequence of the appearance in any law, either an existing law or post-constitution law, of an enactment inconsistent with the Constitution. In order to protect existing law, therefore, it was necessary to use general language which would exclude any suggested consequence of such inconsistency. Hence the wording of section 3.1. Constitution of 1976, by contrast, states in section 2 exactly what the consequence is to be. Any law that is inconsistent with this Constitution is void to the extent of the inconsistency. In order to protect existing laws, therefore, it was appropriate specifically to exclude the one consequence which was expressed to follow an inconsistency, that is, the voiding or invalidating of the other law to the extent the inconsistency. So, my lord, I think it is quite apparent from the way the submission is framed there that, and it is a fact, that all section 6.1 does, as a mirror reflection of section 2, is to address the consequence of a law being inconsistent with the Constitution. It does not address the premise of section 6 of section 2, which is that the law is inconsistent with the Constitution. So that the submission that the learned friends make, with all due respect, establishes the point which we wish to establish, which is that section 6 does not say that an existing law, which otherwise would be inconsistent with the Constitution, is now consistent with the Constitution. All that it does is to address the consequence of inconsistency. What it says is that the existing law is not to be invalidated. We respectfully submit that the question, therefore, that the court is required to resolve is whether the declaration in section 6 that existing law cannot be invalidated means that the power of modification under section 5 of the Constitution Act cannot be exercised. The question cannot be whether section 6, which makes the existing law conform with the Constitution, means that the power of modification cannot be exercised, because of course, if section 6 has that effect, as clearly section 3 of the 1962 Constitution had, and if they had the effect that the existing law conforms with the Constitution, then there will be no question of modifying under section 5. But the whole premise of section 6, we respectfully submit, is that the existing law is inconsistent with the Constitution. It could be invalidated under section 2. What section 6 says is that that consequence does not apply. And it is in that context that the question of the use of the power under section 5 of the Constitution Act applies. Of course, if I may just have a sip of water. Of course, the broader question is whether the modification power can be exercised when section 6 says that the existing law cannot be invalidated. That is the broader question that has to be asked. And of course, you have differences of opinion between the majority and the minority in Matthew. And in relation to the Barbadian provision, you now have the difference of opinion between the majority in Boyce and the minority in Boyce, and of course, the opinions of the Caribbean Court of Justice in Neves and in McEwen. We think, of course, that this issue can be in part resolved by taking a look at the history of the Savings Law Clause as it existed in 1962 and the Modification Clause as it had been applied prior to the enactment of the 1976 Constitution. It is, of course, relevant to understand exactly what the law was, because that would form the understandings which the draftspersons of the 1976 Constitution would have been operating by when they used the words which they used. The Section 3 of the Constitution, as I had already indicated, my lords, is to be found at electronic bundle page 411. The Section 1 of the Constitution, which is at electronic bundle page 409, is in terms almost identical to the Section 4 of the current Constitution. And it says, it is hereby recognized and declared that in Trinidad and Tobago, they have existed and shall continue to exist without discrimination, etc. And then the rights are listed. Section 2 then says, and this is at electronic bundle page 410, that subject to the provisions of section 3, 4, and 5 of the Constitution, no law shall abrogate, abridge, or infringe, or authorize the abrogation, abridgment, or infringement of any of the rights and freedoms hereinbefore recognized and declared, and in particular, no act of Parliament shall, and then there are listed a number of provisions, including subsection B, impose or authorize the imposition of cruel and unusual treatment or punishment, which is now the equivalent of section 5(2)(b). So you have in section 2 a prohibition against any law abrogating, abridging, or infringing any of the fundamental rights and provisions, which would include 5(2)(b). As Lord Hoffman had said in Matthew, that is, of course, language of invalidation. You say no law shall abridge, then obviously if a law does abridge a right, then the consequence must be that the law is invalid. So the presumption of the 1976 Constitution, even though you didn't have a supreme law clause saying what the consequence of inconsistency was, the whole premise of the 1962 Constitution is that a law which was inconsistent with the fundamental rights and provisions is a law which could be invalidated. Now, it is in that context that you then see subsection 3 providing that section 1 and 2 of the Constitution shall not apply in relation to any law that is in force in Trinidad and Tobago at the commencement of the Constitution. So you have section 2 saying no law shall abrogate fundamental rights and provisions, but that is made subject to section 3, and then section 3 says that 1 and 2 shall not apply to existing law. So obviously the section 2 prohibition against abrogation does not apply to existing law. Now, that the way in which section 3 of the Constitution was understood is not in any dispute. You will see, for example, from the very early decision of the Court of Appeal of Trinidad and Tobago in Beckles against Delamore in 1960, so this is within a couple of years after the promulgation of the 1962 Constitution. You see Chief Justice Wooding saying, and this is at electronic bundle, page 1210, at just at letter G, he says, accordingly I hold that it was a law in force at the commencement of the Constitution and was thus exempted by section 3 from the protective restraints imposed by sections 1 and 3 thereof. And then you will see that in 1976, decision of the Privy Council in De Freitas and Benny, a decision which was handed down before the 1976 Constitution came into force. You'll see your Lordship saying at electronic bundle, page 1994, this is just below the letter F, Chapter 1 of the Constitution of Trinidad and Tobago, like the corresponding Chapter 3 of the Constitution of Jamaica, see DPP against Nasrallah, feeds on the presumption that the human rights and fundamental freedoms that are referred to in sections 1 and 2 are already secured to the people of Trinidad and Tobago by the law enforced there at the commencement of the Constitution. Section 3 debars the individual from asserting anything done to him that is authorized by law enforced immediately before August 31st, 1962, abrogates, abridges, or infringes any of the rights and freedoms recognized and declared in Section 1 or particularized in Section 2. And then in the later case of Maraj against the Attorney General, this was a decision in 1979. It was handed down in relation to the 1962 Constitution, but it was handed down after the 1976 Constitution came into force. And you will see that your Lordships are treating with the effect of Section 3 at pages, electronic bundle pages 3269 to 3270. And at letter E, page 3269, the Lordships are reiterating what is said in De Freitas and Benny. And in the third line, In Section 1, the human rights and fundamental freedoms, which it is declared by the only words in the section that are capable of being enacting words, shall continue to exist, are those which are expressly recognized by the section to have existed in Trinidad and Tobago. So to understand the legal nature of the various rights and freedoms that are described in the succeeding paragraphs 8 to K in broad terms, and in language more familiar to politics than to legal draftsmanship, is necessary to examine the extent to which in the exercise and enjoyment of rights and freedoms, capable of falling within the broad descriptions in the section, the individual was entitled to protection or non-interference under the law that existed immediately before the Constitution came into effect. That is the extent of the protection of freedom from interference by the law. Section 2 provides shall not be abrogated, abridged, or infringed by any future law, except as provided by Section 4 and or Section 5. And he goes on, and this is important. What confines Section 2 to future laws is that it is made subject to the provisions of Section 3. In view of the breadth of the language used in Section 1 to describe the fundamental rights and freedoms, detailed examinations of all law enforced in Trinidad and Tobago at the time of the Constitution came into effect, including the common law so far as it had been superseded by written law, might have revealed provisions it could possibly be, plausibly be argued, contravene one or other of the rights or freedoms recognized and declared in subsection 1. Section 3 eliminates the possibility of any argument on these lines. And then Lord Diplock repeats what was said in De Freitas and Benny. So that the Section 3, by providing that the fundamental rights and freedoms did not apply to existing law, resulted in an approach to the Constitution in 1962 that the fundamental rights and provisions applied only to future laws, not to past laws. And that is because Section 3 very clearly said that it had no application to any law that was in existence prior to 1962. So that was the clear understanding of the effect of Section 3 of the Constitution, so that if we had to ask the question whether in 1962 the mandatory death penalty could be challenged, the answer would be no, because there would be no basis for exercising the power of modification under the modification clause in Section 4 of the Order in Council, because the prohibition against cruel and unusual treatment or punishment did not apply to the mandatory death penalty at that point in time. So it would simply have been a non-starter. Now, and that was the state of the law at the point in time that the 1976 Constitution was enacted. As far as the modification clause is concerned, my lords, I think that I don't think that it is very much in dispute that the modification clause could be used, and in fact was used prior to 1976, to effect substantial changes to existing law by replacing words, by inserting phrases as necessary to make the existing law conform with the Constitution. And in fact, you will see in the decision of Chandler against the government of Malaya, you'll see at electronic bundle page 309 that the court replaced the words the police, the Commissioner of Police with the words the Police Service Commission in order to render existing law valid. Otherwise, existing law would have been inconsistent with the Constitution. There was a provision which permitted the Commissioner of Police to terminate the appointment to make appointments to the police service, whereas the Constitution provided that those appointments were to be made by the Police Service Commission. You will see in Beckles and Delamore itself, this is electronic bundle page 128 over to 129, the Court of Appeal saying at letter H, it is urged that assuming the ordinance was an existing law at the commencement of the Constitution was not repealed thereby, it had to be construed with modifications, etc. Right down at the bottom of the page, this is Lord Justice of Appeal Phillips saying, I agree, however, that the ordinance must now be construed as requiring the Governor General to declare that action has been taken or is immediately threatened of the nature and on the scale as set forth in Section 2 of the ordinance.
I'm sorry, Mr. Mendes. Could you give me the page reference again, please?
That is at electronic bundle page 1218 over to
1219.
1219.
Thank you very much. And could you also give me again the page reference for the Malaysian case?
That is electronic bundle page 3049.
Thank you.
And the last reference is to the decision of the, I think it is the Eastern Caribbean Court of Appeal, or sorry, the West Indian Associated States Court of Appeal in, that was a decision again before 1976. And you'll find that at page, electronic bundle page 4501. And just at letter F, you will see an indication of the modification that was made by the court in order to make the existing law conform with the Constitution. You'll see this is Chief Justice Lewis saying, this means that this section will have to be construed as though the second situation envisaged by Section 29(3) of the Constitution were therein provided for, and accordingly this section would read something like this. And then you will see in those passages the words that are being inserted are the words in italics. Is reported guilty of any of these offences by a court trying an election petition, and down below or before the making of the said report. So the words, phrases, long phrases are inserted into the existing law to ensure that they conform with the Constitution. So that the understanding was that the modification clause could be utilized to effect substantive changes to existing law. That has never been in dispute. And all of the authorities that have been put before you indicate that that was the understanding. And now, there are later developments, of course, my Lord, have established that there are limits to the modification power. And I won't go through the cases in any detail because, again, this is not in dispute. But I'll ask you to look at our case at paragraphs 98 to 100, electronic bundle pages 297 to 298. And if I may summarize what is said there, our modification is not exercisable where the inconsistency is too stark to be modified by construction, or the inconsistency presents the court with choices which are more appropriately made by the legislature, where the proposed modification would amount to judicial legislation, where the offending law does not lend itself to sensible interpretation which would permit it to conform to the Constitution. So those are the different formulations which were used, and these are formulations which were used by your Lordship's board in Matthew, both by the majority and the minority. But again, those were developments later on. This was after the 1976 Constitution. The actual limitations to the power of modification were defined in the authorities as we went along. But even before those later developments, that is before 1976, the court had already accepted that there may be occasions where modification was not possible. And when modification was not possible, it was clear that the courts took the position that the existing law would have to be invalidated. So you will see, for example, in the case of Maximia, which is another decision of the West Indies Associated Court of Appeal. This is at electronic page bundle 3394 over to 3395. And you will see at page 3395 at letter D, this is what the Chief Justice said. I agree with counsel for the appellant that the difference between the Constitution and the ordinance in this respect cannot be construed away, to use his own words. It is necessary to try and reconcile this difference by construction. What has happened is that Section 2.2 of the ordinance can no longer stand when read with Section 17.4 of the Constitution, and accordingly, it must be deemed to have been impliedly repealed thereby. Follows that when it is desired to bring a state of emergency to an end, and only law to be followed is Section 7.4 of the Constitution. It is accepted that in the absence of modification, the law is treated as being repealed or invalidated. Similar position was taken by the West Indies Associated Court of Appeal in their decision in Herberts against Phillips. And you will see at electronic bundle page 2539, at letter I, Chief Justice, well, he was Justice of Appeal, Phillips at Lewis at that point in time, he says, I am accordingly of the opinion that Section 3 of the Order of 1959 cannot be construed as required by Section 103 of the Constitution, so as to bring it into conformity therewith. Its provisions are therefore inconsistent with the Constitution, and as a result, Regulation 3 of the Regulations of 1967, the Governor purported to make thereunder, and in pursuance of which the appellant is detained, is invalid, and his detention unlawful. Now, again, that is a position before 1976, and the interpretation of the modification clause, which was taken by the West Indies Associated States Court of Appeal, was approved by your lordship's board in the later decision in the Attorney General's against Reynolds. And you will see that the case of Herberts and Phillips and the related case of Charles against Phillips is dealt with by your lordship in that case at electronic bundle page 4167. And in that case, your lordships did not agree with the Court of Appeal. Existing law could not be modified to make it conform. Nevertheless, they said, paragraph at letter D, this page 4167, if the Court of Appeal were right in concluding that no modification or adaptation or qualification or exception would bring the order in council into line with the Constitution, then they would have been plainly right in holding, that the order in council was nugatory and the emergency power regulations invalid. So again, the accepted position prior to 1976 was that the power of modification was broad, but it had limits. It was accepted that on occasion it may not be possible to find a modification such that you can make the existing law conform. And if you fail to find it, then the existing law would be invalid. And the position in relation to the existing law had been summed up in a very important passage in the judgment of Justice of Appeal Phillips in Beckles against Delamore. This would have been since 1965. And I'll ask you to look at electronic bundle page 1223. Where he said, and this is at letter D, the manifest intention of these provisions, and he was referring to the modification clause in the 1962 order in council, is in my judgment to make every effort to prevent the implied repeal of existing laws, to secure the continuance of their validity insofar as it is possible to make them conform to the provisions of the Constitution. So what you had, therefore, and we must assume that the persons who were drafting the 1976 Constitution was aware, was that if you wished to ensure that the existing law cannot be challenged for inconsistency with the fundamental rights provisions, then you only need a provision such as Section 3, which says that the fundamental rights provision shall not apply to existing law. Authorities have indicated very clearly that Section 3 was a shutout provision, which made, in effect, existing law conform with the Constitution, read without the fundamental rights provisions. And it was also known at that point in time that the modification clause could be utilized in such a way as to effect substantial modifications to existing law. And if you fail to do so, the existing law would have to be invalidated. So, what did the framers of the 1976 Constitution do? You will see the relevant provisions of the 1976 Constitution from around electronic bundle page 427 over to 431. And there, first of all, of course, there's the introduction of the Supreme Law Clause in Section 2, declaring all law that is inconsistent with the Constitution to be void to the extent of the inconsistency. You then have Section 4 and 5 of the Constitution, the pages 428 to 429, which are in similar terms to Sections 1 and 2 of the Constitution. 5 is a bit different in that it says, except as otherwise expressly provided in this chapter and in Section 54, no law may abrogate, abridge, or infringe, or authorize abrogation, etc., of any of the rights and freedoms hereinbefore recognized and declared. And of course, in this chapter is Section 6 of the Constitution, is an electronic bundle, page 430, that says that nothing in Section 4 and 5 shall invalidate an existing law. My Lord, we respectfully submit that the fact that you have now introduced a clause which makes clear what was implicit under the 1962 Constitution, that the effect of inconsistency with the Constitution was invalidation, that did not preclude the utilization of the tried and tested Section 3 of the Constitution. You could simply have, instead of Section 6, said that Sections 4 and 5 shall not apply to existing law. And that would have had the same effect as it was known to have, as determined by this court in the Freitas and Benny. So the fact that the wording of Section 6 is changed has significance, because whereas the utilization of a Section 3 type clause would mean you cannot at all say that existing law is out of conformity with the Constitution, the use of Section 6, focusing on invalidation, does not change the fact that an existing law is inconsistent with the Constitution. The consequence of Section 6 is that it cannot be invalidated. But you have a law that one can say is inconsistent with the Constitution because the fundamental rights provisions apply to it, but you cannot invalidate it. And in those circumstances, unlike the situation in 1962, the door is now open to the consideration whether power of modification under Section 5 can be exercised. That door in 1962 was slammed shut and bolted. You couldn't look to the modification clause at all. Now there is no bar to considering whether the power of modification is to be exercised. And this is why we say that the question that has to be considered now is that whether by prohibiting invalidation, that alone means that the power of modification cannot be exercised. Now, what the respondents say and what the majority in Matthews held was that the change in wording was simply the draftperson's attempt to reflect the declaration in Section 2 that laws which were inconsistent were void, and that meant that there was really no intention to open up existing law to modification under Section 5. We respectfully submit and we rely, my Lord, on the way in which Lord Bingham treated with that argument in his dissent in Matthew. And if I can take you to that, you will see it at electronic bundle page 560 to 561. This is at paragraph 48 of his judgment. At the bottom of 560, he says, in the 1976 Constitution, the wording of the Savings Law Clause was changed. The wording of Section 3, Section 1 and 2 of this Constitution shall not apply. It was discarded and replaced in Section 6. Nothing in Sections 4 and 5 shall invalidate. The state contends that this change of wording was intended to effect no change of meaning. We find this unconvincing. If a form of words has acquired a clear and settled meaning, and the draftsman wishes to reproduce that meaning in a later statute, he uses the same form of words again. It suggested that the new wording was a response to Section 2, the Supremacy Clause, new Constitution. And we accept that it may well have been. If it had been intended that Sections 4 and 5 of the new Constitution should not apply to an existing law, there could have been no reason for not saying so. And then goes on to consider in paragraph 49 the ordinary meaning of the words invalidate. He says the Oxford English Dictionary defines the transitive verb invalidate as meaning render invalid, to destroy the validity or strength of an argument, contract, etc. To render of no force or effect, especially to deprive of legal efficacy, to make null and void. This definition reflects ordinary usage. Section 6.1 provides that nothing in Section 4 and 5 shall render invalid or destroy the validity or strength or render of no force or effect or deprive of legal efficacy or make null and void any existing law. These meanings are, in our opinion, directed to total invalidity. This again reflects ordinary usage. If a passport is invalidated, it will be null and void for all purposes. If a ticket is invalidated, you cannot travel on it. If a credit card is invalidated, it cannot be used. But whereas Section 2 provides that any law other than the Constitution that is inconsistent with it is void to the extent of inconsistency, Section 6 provides that nothing in Section 4 and 5 shall render an existing law null and void, devoid of all force and effect, wholly invalid. This does not preclude the application of Section 5.1, requiring an existing law, true with such modifications, adaptations, modifications, and exceptions as may be necessary to bring it into conformity with Sections 4 and 5, where this can be done without annulling the existing law. To read the provisions in this way is to give effect to the principles of construction set out above, in a way which the interpretation favored by the majority not. We rely respectfully on those passages. Principles of construction that Lord Bingham was referring to is the well-recognized principle of construction that fundamental rights and freedoms are to be construed generously, whereas provisions such as savings law clauses are to be construed narrowly. Now, we submit that Section 6 is to be construed narrowly, and it is to be confined to ensuring that Sections 4 and 5 do not affect the validity of existing law, ought not to be interpreted, to be interpreted to give full effect to the enjoyment of fundamental rights and freedoms, and it ought not to be interpreted expansively to nullify the power of modification under Section 5. Now, we respectfully submit that that is precisely what happens when Section 6 is construed as, in effect, transforming an existing law which does not conform with the Constitution into one that does conform with the Constitution, which is the working assumption of my learned friends for the respondent in this appeal, and also appears to be the working assumption of the majority in Matthew, as I've already indicated. That is to give Section 6 not a narrow construction, but an expansive construction, as a matter of fact, an extravagant construction. Even if we say that, even if we leave to one side for the moment, that it is simply not possible to construe Section 6 as transforming non-conformity into conformity, respectfully submit that the prohibition against invalidity ought to be confined just to that and ought not to be construed as preventing the power of modification under Section 5. More so since under Section 5 there is a command to the judiciary to modify existing law to bring it into conformity with the Constitution. My Lord, these principles or canons of construction are well known, and they were applied by the Caribbean Court of Justice in the Nervais case. You'll see at electronic bundle 668.
Sorry. The page again, please. 668.
668, my Lord. You see at paragraph 68, at page 668, you'll see Sir Dennis Byron, who is then the president of the court, saying, "We are satisfied that the correct approach to interpreting the general savings clause is to give it a restrictive interpretation, which would give the individual full measure of the fundamental rights and freedoms enshrined in the Constitution. This interpretation should be guided by the lofty aspirations by which the people have declared themselves to be bound. A literal interpretation of the savings clause has deprived Caribbean peoples of the fundamental rights and freedoms, even as appreciation of their scope have expanded over the years. Where there is conflict between an existing law and the Constitution must prevail, and the court must apply existing law as mandated by the independence order. Such modifications as may be necessary to bring them into conformity with the Constitution. In our view, the court has a duty to construe such provisions with a view to harmonizing them where possible through interpretation, and under its inherent jurisdiction by fashioning a remedy that protects from breaches and vindicates those rights guaranteed by the Bill of Rights." And the court said similarly in the McEwen case, electronic bundles 589, at paragraph 46. This is in the words of the current president of the court, Justice Saunders. He says at 589, "A restrictive interpretation and or application of the savings clause is always warranted. There's a simple reason for this. It is the duty of the court to adopt a generous interpretation of the provisions related to fundamental rights. As far as possible, full effect should be given to the guarantees promised to the citizen in those rights. Several judges have affirmed this essential principle. Savings law clauses must be given a narrow construction." And then he footnotes the decisions of this board in Whiteman against the Attorney General, of this board in Watson against the Queen, which is the trilogy, the third in the trilogy of cases. Then the Queen against Hughes, the Attorney General against Grenada against Cord, and then of course the decision of the CCJ in Severin. So those are all decisions of the Privy Council and of the CCJ, and those were the guiding principles that had been in Lord Bingham's mind when he interpreted Section 6 of the Constitution in the passage that I have just read to you.
Can I ask you, Mr. Mendes, if we look at Section 6 for a moment, on page 430 of the bundle. We've been focusing on Section 6(1)(a).
Yes.
If we can see there are also B and C. And I suppose your argument would you would advance the same argument, I think, in relation to those. So, for example, in C, nothing in sections 4 and 5 shall invalidate an enactment that alters an existing law. but does not derogate from any fundamental right guaranteed by this chapter in a manner in which or to an extent to which the existing law did not previously derogate from that right. So it's not invalidated, but you would say it could be modified.
That's correct, my lord.
Yeah. If we look at subsection 2, that tells us that where an enactment repeals and reenacts with modifications an existing law and is held to derogate from any fundamental right guaranteed by this chapter in a manner in which or to an extent to which the existing law did not previously derogate from that right, then, subject to sections 13 and 54, the provisions of the existing law shall be substituted for such of the provisions of the enactment as are held to derogate from the fundamental right in a manner in which or to an extent to which the existing law did not previously derogate from that right. So that's envisaging that you might have there might be an existing law which derogated from rights protected by the Constitution. That law might be repealed and reenacted with modifications which derogated even further from the protected right. And in that situation, you're told that the provisions of the prior law are to be substituted.
Yes,
So you could be, under that provision, you could be substituting provisions which themselves derogated from fundamental rights protected by the Constitution. Do you agree?
Yes, my lord, but that would be subject to the exercise of the power of modification under Section 5. That doesn't exclude the power of modification. What it does mean, of course, is that if you found an existing law which could not be modified, then that subsection 2 would apply to that existing law. So it would remain it would remain as is, as it were, or the law which modified it and derogated to a further extent would now be read as only applying that existing law. But again, that does not exclude the power of modification. You start with the power of modification.
Well, what I'm wondering in relation to subsection 2 is why would the Constitution not simply require the new enactment to be modified so as to conform to the Constitution? Why go to the trouble of requiring the new enactment to have its provisions substituted by the prior law and then modify that? It seems a terribly long-winded way of going about arriving at a result that conforms to the Constitution.
My lord, what I'm saying that Section 2 will have to be interpreted in light of Section 5 of the Constitution Act. That is to say, the assumption is that the existing law is already modified to make it conform. But if it cannot be modified, then that is the existing law that you're dealing with under subsection 2. My lord, your lordship's board had made it clear in the decision in Bow from the Bahamas that the modification exercise that has to be engaged in is to be treated as taking place upon the enactment of the Constitution. You will recall, of course, that in Bow you had a situation where the first Constitution that the Bahamas had was one which did not have a savings law clause at all. And then they got a new Constitution which contained the savings law clause, and it was being argued then, after the new Constitution had come into force, that the mandatory death penalty was to be read as modified. And of course, the argument that was being made was, well, the present Constitution has a savings law clause. And your lordship said that the mandatory death penalty would have to be construed as having been modified since the first Constitution came into force. in order to bring it into to conformity, so that the existing law that was in place when the new constitution came into force would have been a law that had already been modified. I'm saying that that same principle applies here. The act of modification is taking place upon the enactment of Section 5, even though, of course, that doesn't happen until much later on. You may say, in other words, that the modification takes place retroactively, so that we respectfully submitting that the existing law that we are speaking about in subsection 2 would be an existing law that is modified, and if it is already modified and it conforms, then subsection 2 really doesn't have to be applied. But if it cannot be modified and therefore has to be left in its pristine form out of conformity with the Constitution, then that is when section 2 is applied, and you basically ignore the further derogation under the law that is passed after the Constitution, and you replace it by the existing law which cannot be modified. So that is the way we see that it would work.
Thank you, Mr. Mendes.
Now, my lord, the respondent says that if the Constitution is now to be construed as permitting the existing law to be modified, then the declaration in Section 4 that the fundamental rights and freedoms have existed would be misleading. You will see that argument at electronic bundle, page 369, at paragraph 99. So that he is saying that this is an additional reason why you should interpret Section 6 as preventing modification under Section 5. Now, we say in answer to that the only reason why the fundamental rights and freedoms under the 1962 Constitution was treated as being defined by existing law was precisely because Section 3 of the Constitution said that existing law the fundamental rights and freedoms shall not apply to existing law. And that is made plain from the passage from your Lordship's decision in Maraj that my learned friend relies upon. Again, the working theory in DPP against Nasrallah and the Freitas against Benny was that fundamental rights and freedoms had already been guaranteed by the laws which were enforced prior to the Constitution coming into play, even though, of course, that inconsistencies have been identified from time to time thereafter. But the theory was, or the presumption was, that the law enforced already guaranteed those rights. But it is made plain in the judgment of Lord Diplock in Maraj that the reason for that was the very Section 3 of the Constitution. If you look at electronic bundle, page 3269, in the last paragraph, I have already read it to you, so I'll just refer you to the first sentence. It says, Lord Diplock says, what confines Section 2 to future laws is that it is made subject to the provisions of Section 3. Then he goes on to say that without Section 3, it would have been possible to say that existing laws were inconsistent with the fundamental rights provisions in Section 1 and 2. But that Section 3 then eliminates the possibility of any argument along those lines. So it was not the declaration in Section 4 that the rights have existed and continue to exist that protected existing law from scrutiny or compliance with the fundamental rights provisions. It was Section 3 which prevented it, and it was Section 3 which led to the working theory of the existence of a presumption. But as your lordships have made clear in Matthew and in Boyce, it is a presumption only, and it of course can be rebutted. And it has been rebutted time and time again because it was a unanimous view of your lordships in Matthew and Boyce and Watson that the mandatory death penalty was in violation of the prohibition against cruel and unusual punishment. So the construction that we are asking you to put on Section 6 and Section 5 does not disrupt that theory, or I should say, it disrupts it, yes, but that's because we don't have a Section 3 anymore. There is no longer a provision that exempts existing law from compliance with the fundamental rights provisions. We now have a provision that simply says that the fundamental rights provision shall not invalidate an existing law. Now, we shall make the note, my lord, that Section 6 of the Constitution shall not invalidate is different from Section 26 of the Barbadian Constitution. Section 26 of the Barbadian Constitution provides that nothing in existing law shall be held to be inconsistent with the fundamental rights provisions. Section 6 does not do that. All it says is that it shall not invalidate. Now, despite the, if I may say, the broader terms of Section 26 of the Barbadian Constitution, Lord Bingham was nevertheless felt that there was room for the operation of the modification clause. And he had expressed that view, of course, in the decision in Boyce. And if I may take you to what he said in Boyce at electronic bundle pages 530 to 531. It says at the bottom of paragraph 78, going over, it says that, sorry, I'll take you to 79. Section 26(1) of the Constitution prohibits a court from holding any provision of an existing law to be inconsistent with Section 12 to 23 of the Constitution. Were it free to do so, the consequence would necessarily be under Section 1 of the Constitution that the provision would be void. But if it were contended, for example, that the imposition of the death penalty under an existing law in any case, even if discretionary, was inconsistent with 12 or 15 of the Constitution, but accede to that contention, to do so would be to avoid the existing law, which cannot be done. That is not what the appellants seek, nor what, in our opinion, they are entitled to seek. They seek not the avoidance or abrogation of an existing law, but its construction with such modifications, adaptations, and exceptions as may be necessary to bring it into conformity with the Constitution. To modify Section 4 of the Offences Against the Persons Act 1994 so that it reads, any person convicted of murder may be sentenced to and suffer death, is not to emasculate, avoid, or render nugatory that section. It does not preclude imposition of the death penalty. A case where a judge seized of all the facts considers such penalty to be just and appropriate, but it is to preclude the infliction of what is now recognized to be inhuman and degrading punishment or other treatment. And then he goes on, sorry, paragraph 80. The construction of these provisions, which we favor, is in our view fortified by the recognition in Section 26, I think it's 9 of the Constitution, that an existing law may have been modified, which can only refer to the exercise of the duty under Article 4. There's also a clear contrast in drafting of the human rights provisions of the Constitution shall not apply, as in Section 23(5), and nothing shall be held to be inconsistent in Section 23(4) and 6. Former provision precludes any review of conformity and hence any exercise in power to modify. The latter does not. Unless the effect of these alternative formulae leads to a difference of meaning, the draftsman must have used different expressions. The cardinal rule of drafting to use the same expressions to mean the same things and different expressions to mean different things. So that even though the Section 26 of the Barbadian Constitution was crafted in broader terms than Section 6, but Bingham was still of the view that it did not preclude the exercise of the modification power under the corresponding provision in the Order in Council applicable to Barbados. In other words, what he was doing there was reading the modification clause and the savings law clause together. And indeed, in Mervais and McEwen, the Caribbean Court of Justice followed his lead. They held the modification clause and the savings law clause were to be read together. The savings law clause being interpreted narrowly. If I can take you to Mervais page, electronic bundle page 668, paragraphs 68 to 69. I think I've already taken you to parts of those paragraphs. Well, actually, I've read to you paragraph 68 already. In Mervais, and if I can just take you then to the corresponding paragraphs in McEwen, to the electronic bundle pages 592 to 593. This is 58 to 59, where Justice Saunders says, by a narrow margin of 5 to 4, the conventional wisdom carried the day. The majority, and he's referring to voice. Majority held that the savings clause was a complete ouster of any jurisdiction to review existing law to test their constitutionality. The minority, on the other hand, took the view that the effect of the savings clause read together with the modification clause, that is the section akin to Section 7.1 of the Guyana Constitution Act, was to permit the court to identify an inconsistency between an existing law and the fundamental rights in the Constitution, and to modify the inconsistency out of existence. The savings clause would only be needed where it proved utterly impossible to modify the existing law to make it conform with the Constitution. Among the 4 dissenters was Lord Bingham, the president of the court, and arguably one of the finest judges of the United Kingdom has ever produced. And so essentially, he was indicating that the court was following the reasoning of Lord Bingham in the dissent in Boyce. Now, our submission, my lord, is that if the Caribbean Court of Justice and Lord Bingham for the minority in Boyce found themselves able to construe the more expansive Barbadian provision as not precluding modification, then it is guaranteed, I would respectfully submit, that the Caribbean Court of Justice would also construe Section 6 of the Trinidadian Constitution, if they had the chance to do so, as not precluding modification. Because, of course, on the face of it, the Barbadian provision goes further than does the Trinidadian provision. The Barbadian provision addresses the question of inconsistency directly, whereas the Trinidadian provision does not do so. Now, the consequence of all of this, my lord, is that there are now 2 views as to how Section 6 of the Constitution of Trinidad and Tobago is to be read along with Section 5 of the Constitution Act. One view, of course, is that held by the majority of your lordships in Matthew. But that view, of course, retards fundamental rights and freedoms to the extent that it preserves laws which violate constitutional rights. The other view, which is held by the Caribbean Court of Justice and by the minority in Matthew and Boyce, is the view which promotes constitutional rights. And if it is accepted, it will also allow Trinidad and Tobago to comply with its international obligations. So that is the reality. We now have before you 2 competing views as to how these 2 provisions are to be reconciled, and the consequences of one or the other are very stark. Now, we say, of course, that it is necessary to give Section 6 a narrow construction, and of course that submission accords with the principle, is not in dispute, that savings law clauses must be narrowly construed. On the other hand, we respectfully submit a case which the respondent is putting before the court, and indeed the construction of Section 6, which Lord Hoffman accepted in Matthew, gives Section 6 a broad, even extravagant construction, and is therefore not in accordance with the accepted principles of construction of constitutions. minority view, on the other hand, in Matthew, and the CCJ in Nervais and McEwen, are to be preferred because they apply a narrow construction. In other words, they apply the uncontroversial and commonplace canons of construction to provisions like Section 6. But you will see from reading Lord Hoffman's decision in Matthew that he made no attempt whatsoever to give Section 6 a narrow construction. In fact, he didn't even consider it. From the word go, he operated on the assumption that Section 6 meant only one thing, even though he didn't condescend in his judgment in Matthew itself to say that it meant that existing law conformed with the Constitution. It seems clear that when you read Boyce together with it, that he thought that Section 6 had the same effect, if not meaning, as the earlier Section 3 shall not apply, and the same effect as Section 26 shall not hold to be inconsistent. So he made no attempt to find a construction that was different from what those provisions may otherwise have produced. Therefore, we say that he fell into error, as do my learned friends for the state, in making no attempt to give Section 6 a narrow construction. My lords, my lady, our case is that this court must now apply the principle where provision in a law, and including a constitution, is ambiguous. The sense is reasonably susceptible of more than one construction, and the construction which promotes constitutional rights and international obligations is to be preferred. My lord, you will see that that is a principle that was accepted by your lordships in the decision in Worm, which you will see at electronic bundle page 250505. It was the decision in Worm against the Commissioner of Police. Some of the page you'll see your lordship say, where possible, legislation should be interpreted in such a way that it is consistent with the Constitution.
Could I have the page number again? I'm sorry.
2505.
2505.
2505, my lord.
Thank you.
The interpretation which your lordships would in any event be disposed to adopt tends to make the relevant provisions conform to Section 8(1)(a) of the Constitution. So the principle is that you must interpret legislation in such a way as to be consistent with the Constitution. We say that that principle is given expression in this way, where you have two reasonable interpretations of the Constitution, you should choose the one which promotes fundamental rights. And of course, there is, McEwen adopted a similar approach. If you look at electronic bundle page 588, and paragraph 41, you will see that President Saunders said, we reiterate those statements here. Law and society are dynamic, not static. The Constitution must be read as a whole. Court should be astute to avoid hindrances that would deter from interpreting the Constitution in a manner faithful to its essence and its underlying spirit. If one part of the Constitution appears to run up against an individual fundamental right, then interpreting the Constitution as a whole, court should place a premium on affording the citizen his or her enjoyment of the fundamental rights, unless there is some overriding public interest. So that is the approach which we are asking you to take in the face of competing interpretations of the interaction between Section 6 and the modification clause. As far as the principle in relation to the upholding of international obligations is concerned, again, that is a principle that is not in dispute. You'll see in Matthews at electronic bundle page 564, the paragraph 55, and I think this is it would have been in Lord Bingham's judgment, he says, it's common ground between the parties to this appeal and an obligation binding on a state in international law, but not forming part of its domestic law cannot override or even influence the construction and application, clear and unambiguous provision of a domestic law. It is also common ground that if a provision of a state's domestic law is ambiguous and permits of two interpretations, which will accord with the state's international obligations, and the other which will involve a violation of these obligations, the court will so far as possible adopt that interpretation which will accord with the state's international obligations. That principle is also accepted by the majority in Boyce, and you will see that at electronic bundle 516 to 517. At the bottom of page 516, 4 lines from the bottom, this is what Lord Hoffman said, but international law can have a significant influence upon the interpretation of the Constitution because of the well-established principle that the court will so far as possible construe domestic law so as to avoid creating a breach of the state's international obligations. So far as possible means that if the legislation is ambiguous, in the sense that it is capable of meaning, a meaning which either conforms to or conflicts with the treaty, what will, other things being equal, choose the meaning which accords with the obligations imposed by the treaty. My Lord, you will see that in Matthew, Lord Bingham analyzes the international obligations to which Trinidad was subject at the time. You'll see him doing that electronic bundle pages 564 to 568. That is paragraphs 55 to 59 of his judgment, before concluding at paragraph 59, page 568, electronic bundle 568, he says at 59, it is in our opinion clear that the effect of reversing Rudal is to put the state in breach of its international obligations under the Universal Declaration, ICCPR, American Declaration, and the American Convention, all of which the state was party, and the appellant committed this crime, and to the first three of which it remained a party at the date when he was sentenced. In acknowledging, as it does, the imposition of the mandatory death penalty's cruel and unusual treatment or punishment, the state must indeed be taken to admit these breaches of international obligations. And so that was one of the reasons why Lord Bingham was minded to true mandatory death penalty in that case in such a way as to make it conform, in order that Trinidad and Tobago could be in compliance with his international obligations. But you will see a similar analysis in Neves at electronic bundle 649 to 651. This is at paragraphs 12 to 19, which, my Lord, I'll just refer you to without reading. And you will see the court concluding at paragraph 19 at page 651. And this was in relation to Barbados. So Dennis Byron says, it is indisputable that the government of Barbados has acknowledged that the mandatory sentence of death under Section 2 of the Offences Against the Persons Act, and the immunizing effect of Section 26 of the Constitution, violate its obligations under international law. Nor does anyone dispute that Barbados has given undertakings into Inter-American Court of Human Rights, and to this court to rectify these violations, commence the process of rectification through legislation already tabled in Parliament. All of this has been reflected in the consistent performance of the Barbados Privy Council in the commutation of the mandatory death sentence whenever imposed. Against this backdrop that we now turn to discuss the issues identified at 4 above. So that there is no dispute really that the continuance of the mandatory death penalty and the protection that it receives by the interpretation which the majority in Matthew has put upon Section 6 of the Constitution, puts Trinidad and Tobago in violation of its international obligations. My learned friends in their written submissions make the point that Trinidad and Tobago is no longer a signatory to the Inter-American Convention, and indeed they had withdrawn because of the position that the court was taking in relation to the mandatory death penalty. But we still remain bound by the Declaration on the Rights of Man. We're still a signatory to the National Covenant on Civil and Political Liberties. Of course, the declaration is applicable to all members of the United Nations. And if I can just refer you to very briefly to what is said in the International Covenant on Civil and Political Rights. It is not among the, it's not in the electronic bundle itself, my lords, my lady, but I've asked my learned friends to have copies so that they can be handed up. I'm referring to Article 2 of the Covenant.
If you just give us a moment, Mr. Mendes, I'll just see if we do have copies available.
I'm much obliged.
I understand we will provide it, my lord.
Very well. Just proceed, Mr. Mendes. Thank you.
Thank you very much, my lord. Article 2.1 says that each state party to the present covenant undertakes to respect and to ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. And then goes on to say similar things in 2. And then in 3A, it says each state party to the present covenant undertakes A, to ensure that any person whose rights and freedoms as herein recognized are violated shall have an effective remedy, notwithstanding that the violation has been committed by persons acting in an official capacity, and B, to ensure that any person claiming such a remedy shall have his right thereto determined by competent judicial, administrative, or legislative authorities, or by any other competent authority provided for by the legal system of the state, and to develop the possibilities of judicial remedy. We say, of course, my lords, my lady, that Section 6 of the Constitution, as interpreted by the majority of the Lordships Board in Matthew, puts Trinidad and Tobago in direct violation of Article 2.3a, 2.3.2a and b, to the extent that someone like the appellant in this case, who alleges that the imposition of the mandatory death penalty upon him violates the corresponding rights in the International Covenant. That is, we find that in Article 7, no one shall be subject to torture or to cruel, inhuman, or degrading treatment or punishment. By interpreting Section 6 as precluding any judicial remedy against the mandatory death penalty, Trinidad is put in direct violation of its international obligations under that treaty. And of course, my lord, there are numerous authorities cited by Lord Bingham in those passages that I referred you to which we refer as well in our case. So we respectfully submit that this is a principle of interpretation which ought to be applied, having regard to the fact that there are now two reasonable views as to how Section 6 and Section 5 of the Constitution Act are to be read together. I say, my lord, that there are now two different views because, of course, the majority in Matthew did not think that the opposing view, which was accepted by the minority, was a reasonable view. And indeed, Lord Hoffman had expressed the interpretation which had been put upon the modification clause in Boyce and in Matthew to some extent as being irrational to the point of perversity. You will see in Boyce, for example, at electronic page 524, in paragraph 54, He says that the attractive force of international human rights law and the living instrument principle have already been touched upon in their proper place. The Lordships repeat that they do not intend to put in doubt the principle is reasonably possible, that if it is reasonably possible to give domestic law a construction which will accord with international law obligation, the court will do so. But the construction of Article 4.1, for which Mr. Starmer contends, is unreasonable to the point of being perverse. There is no ambiguity about the matter. Of course, my lord, that is Mr. Starmer's argument that the minority in Boyce and the minority in, well, Mr. Fitzgerald's argument in Matthew, that the minority in Matthew accepted. But Lord Hoffman and the majority were obviously of the view that that was a perverse construction of the Constitution, and therefore that precluded any application principles of construction that we are relying on in this case. It also, but as we say, the majority in Matthew only came to the conclusion that the interpretation of the minority was perverse because the majority failed to seek to put a narrow construction on Section 6 of the Constitution. And indeed, they put an expansive construction upon it, going to the extent of saying that Section 6 it was to render something inconsistent to be consistent with the Constitution. Now, we respectfully submit, therefore, that if your lordships find, and we respectfully submit that you fail to find, if I may say, that the views of Lord Bingham and the minority in Matthew and of the CCJ and the views that have been advocated here are reasonably available constructions of Section 6, then you should give effect to that construction, applying the principles that we rely on. And in those circumstances, my lord, you should hold Matthew must now be considered to be wrongly decided. I'm saying now be considered because we now have the views of the Caribbean Court of Justice as to how savings law clauses and modification clauses ought to be read together in the context of a provision in Barbados, which was broader than the Section 6 that we are speaking about here. We respectfully submit that the construction that we rely on and that the CCJ has upheld is not irrational, as the majority in Matthew and Boyce held. We say it is not irrational to adopt a view which would confine the operation of Section 6.1 to laws which cannot be made to conform with modification. In other words, we accept that there are some laws, some existing laws which cannot be modified to make them conform, like, for example, the death penalty itself as a penalty. In other words, even if you were to find that the death penalty violates the Constitution in one way or the other, then Section 6 says that it cannot be invalidated, and therefore there is no modification that you can think of that would make it conform. There are modifications that you can possibly think of that might modify its application, but not to make it conform itself. And therefore, that is one circumstance in which the modification clause could not be used, and Section 6.1 would have effect. But we say that that is not an irrational conclusion, or it certainly is not an irrational result, because what you would have happen is that a number of laws which are part of the existing law in Trinidad and Tobago will be modified to make them conform with the Constitution. And what we'll be left with is probably a small number of cases where modification is not at all possible. That is not an irrational result. And indeed, Lord Bingham rejected that the charge that his interpretation was irrational, and we rely on what he said. You'll see at electronic bundle, page 564, at his paragraph 54, said, I'm reading from letter E, the result of our construction is we accept, require the rectification of some disconformities while leaving others unrectified. Those which cannot be rectified will generally be matters which call for legislative deliberation and on which the court is not well equipped to intervene. They will not necessarily be the most flagrant or obvious infractions of human rights. Here's the observations of Lord Hope in Billinger against Billinger. We cannot regard this outcome as less irrational, less likely to have been intended than a prohibition for an indefinite period of rectification of any disconformity, whether large or small. And of course, my lord, the view which the Supreme Court of Justice has taken, having savings law clauses which protect all existing law for an indefinite period of time, is well known, and as you will see from their judgments, they certainly consider it to be an irrational position take that you protect existing laws for an indefinite period of time until the legislature decides that they're going to change it in order to make them conform with the Constitution. My lord, Trinidad and Tobago will be celebrating 60 years of independence in August 2022. And it has been known for quite a long time now that the mandatory death penalty is a cruel and unusual punishment. There has been some talk about categorizing murder. No step has been taken to do the simple thing of amending the Section 4 of the Offences Against the Persons Act along the lines that have been suggested by your lordship in Hughes, Fox, and Reyes. No steps have been taken. Recently in the Johnson case, this court had to deal with a law which required married women to retire from the public service, where there was no such requirement in relation to married men. And that is after many years of independence, no step having been taken to rectify the law. And there are a number of other examples that we could put before your lordships, which I think my learned friend Mr. Fitzgerald will have those references to give you in due course. But the consequence of the interpretation that the majority in Matthews put upon Section 6 is to keep in play, to keep valid a number of laws which violate the fundamental rights and freedoms of the Constitution, without any real indication of an attempt on the part of any of the many governments who have been in power in Trinidad and Tobago since 1962 to engage in a comprehensive examination of the existing law to try to bring them up to date with the current understandings of the provisions of the Constitution. So that is the situation that we are faced with. We would respectfully submit it is, as Lord Bingham put out, position that we advocate is no less rational than a position, or I should say irrational, than a position that you keep existing laws in force for an indefinite period of time. We respectfully submit that it is not a relevant consideration. Section 5, that is to say the modification clause, is not to be found in the Constitution itself, but it's in the Constitution Act. We respectfully submit that it is in the instrument which brought the Constitution into force, that this was an act of the Parliament of Trinidad and Tobago, exercising the authority which was vested in it by the 1962 Constitution to amend the Constitution and indeed to replace it by a new Constitution altogether. And in the exercise of that undoubted authority, they at one and the same time mandated the judiciary to modify existing laws to bring it into conformity, at the same time as it provided in the Constitution that the fundamental rights provision shall not invalidate existing law. So the fact that it is contained in the Constitution Act, we respectfully submit, is not a mark against the construction that we have put before the court. So, my lord, of course, we come to the point where we have to ask the question whether the if your lordships, of course, are persuaded that Matthew is now to be considered to be wrongly decided, whether you should overrule Matthew. That is not it's not a foregone conclusion that because you think that Matthew is wrong, that you should overrule it. We have presented in our submissions the reasons why it would be appropriate to overrule Matthew if you agree with the submissions that we have put forward. I'll ask you to look at our case at electronic bundle pages 334 to 335, paragraphs 211 to 216. I'll try my best, my lords, not to repeat them. We, of course, rely on the reasons given there. And just to note that the first reason, which is given at page 334, paragraph 211, is that a 9-member panel of your lordship's board has been assembled specifically to consider whether, in the light of the decisions of the Caribbean Court of Justice, Matthew should be overruled in relation to Trinidad. And we make the point that it was that very reason which was given in Matthew and Boyce for overruling Rudall. That is to say, that you had a 9-member panel sitting to consider whether Rudall was wrongly decided. My lord, the significance of the size of the panel is that difficulty with overruling previous decisions has always been that it may be that you're giving litigants the opportunity to raise a question that has already been decided by a previous board, even if by a majority, before another board whose views might be different, so that justice would effectively be the luck of the draw, as it were, the luck of who happens to be sitting on the case at the relevant point in time. But when the members of the court sit en banc, which is the expression that is used in the United States, then the possibility of that happening is reduced. So this is what your lordships were referring to in Matthew and Boyce when it relied on the fact that a 9-member panel was sitting as justification for overruling Rudall. This board has been assembled, no doubt, to also consider whether Matthew, it would be justifiable to overrule Matthew in the circumstances of this case. You also make the point, my lord, that Rudall was decided by a majority in relation to Trinidad and Tobago. And your lordships took the position then that Section 6 ought not to be interpreted in such a way as to exclude the power of modification. Rudall was short-lived because it appeared that some of your lordships who then sat on the case in Boyce, which came up not long after, had misgivings about Rudall, and therefore the 9-member panel was assembled in order to determine whether Rudall should be applied in relation to Barbados. And my lord, we take the position, of course, that it is unfortunate for Trinidad and Tobago that did happen, because the provision in Section 6 is different, markedly different to the provision in Section 26 of the Constitution of Barbados. And really and truly, as we submit now, court ought not to have taken the position that the two provisions were to be equated. In other words, it is possible, although the CCJ has not accepted that position, it's possible, or I should say it is more persuasive to take the position that this Barbadian Section 26, by declaring that this existing law shall not be held to be inconsistent, is closer to the provision that says fundamental rights and freedoms shall not apply to existing law. So it's a mark of regret, certainly, that Rudall was thought to have automatically determined the outcome of the case in Barbados. And therefore, because there was a Barbadian case and because it was thought that would automatically determine the events in Boyce, was revisited. What we now have is Barbados' current highest court of appeal has determined the correct position is the position of the minority in Boyce. So it is just, I suppose, a lack of faith that Rudal, that the appeal in Boyce came up so soon after Rudal. Otherwise, we would have been in a position where by now, part of the laws that are existing laws that are inconsistent with the Constitution have been modified, and they would have been conforming with the Constitution, including, of course, the mandatory death penalty. But what we have suffered as a result is that since Matthew was decided in 2005, that whenever someone has been found guilty of murder, they have been a cruel and unusual punishment has been imposed upon them by the judiciary. That is the situation that we have faced. We say that now that the position in Barbados has changed, in other words, the premise of the review of Rudal has now changed. We respectfully submit that it is open to this board to go back to Rudal if you find, of course, it was not rightly decided. We say as well that Matthew continues to effect injustice in Trinidad and Tobago by keeping in force laws which are inconsistent with the Constitution. Ironically, my learned friends cite that as a reason for not disturbing Matthew. They say that you should not disturb Matthew because Matthew has been applied in Trinidad and Tobago for the last 16 years. We say that that means that every time Matthew was applied, it meant that the court was upholding a law, an existing law that was inconsistent with the Constitution. We respectfully say you can't rely on commission of a further injustice to keep in play a law which this court presumably considers to have been wrongly decided. We say, of course, as well, that Matthew upholds the mandatory death penalty and therefore it puts life at stake. The interpretation of Section 6 accepted Matthew puts lives at stake. And that was the basis for your lordships reversing the decision in Reckley, which was decided in 1996, and the decision of the Your Lordships Board in De Freitas and Benny. That was done in the case of Lewis, which was decided, I believe, in 2001. The De Freitas and Benny, which was decided around 1976, was the law which was applied in Trinidad and Tobago for 16 years up until 2001. That was accepted law applied until 2001. But your lordships found it, having disagreed with the ruling in De Freitas and Benny, found it justifiable to overrule it, despite the fact that it had been applied for that period of time, precisely because the life of people were at stake in the rulings that the court was called upon to consider. The fifth reason we give is that the Caribbean Court of Justice was established for the purpose of forging a Caribbean jurisprudence, and that is what the court itself has said in one of its earlier rulings in the Boyce case. It is true that Trinidad and Tobago is not yet signed on to the final appellate jurisdiction of the CCJ, but the fact is that Trinidad and Tobago has signed on to the treaty with our brother and sister nations in the region to establish the Caribbean Court of Justice. It is already established for all of the nations in the region in its original jurisdiction, that is, for its the enforcement of the CARICOM Treaty. But as yet, Trinidad and Tobago has not signed on. But it is significant that Trinidad and Tobago lobbied for and obtained the Court of Justice as the seat of the Court of Spain. And of course, as we say, the last reason is that there have been developments since Matthew was decided, and in particular, the decisions of the CCJ in Neves and in McEwen. Those are reasons we respectfully submit why why you should overrule Matthew.
Mr. Mendes, can I say that it would be helpful to the board to understand what the ramifications of departing from the reasoning in Matthew might be. Evidently, the laws that have been regarded and understood to be saved by Section 6 following Matthew are by no means confined to the death penalty.
That's correct.
We look, for example, at the Johnson case, which is about sex discrimination laws.
Hello.
And there must be many other laws also which are affected. And I dare say, just thinking about the Privy Council's case law, if we depart from the reasoning in Matthew, then logically we would also have to depart from the reasoning in a number of other cases. Johnson is an example, I think.
Yes,
and there may be case law in the courts of Trinidad itself, the local courts, which would be affected by our overruling Matthew. It would be very helpful, and so far we're only talking about Trinidad. There may be wider ramifications for other jurisdictions besides. It would be very helpful if Council were able to assist the board. And I don't expect you to do this off the cuff immediately, but it would be helpful if we could be provided with information about the extent to which departing from Matthew would require us also to depart from other case law of our own, or would affect case law in Trinidad, in the local courts, or would have wider ramifications.
My Lord, Mr. Fitzgerald has a list of pieces of legislation, existing law, which we say could be impacted, or I say which we say are continued in force as a consequence of the majority ruling in Matthew. One example is, of course, the mandatory death penalty. Another example is that we have laws in our immigration acts which prohibit or which render homosexuals or mentally defective persons to be prohibited immigrants. So that such laws would have to come under scrutiny to see whether they could be modified. And there are other examples. For just thinking off the top of my head, you have in some of the existing laws, you have reverse burden provisions, which could be subject to review under in light of the learning of your lordships in the Supreme Court in Lambert against the Queen, for example, so that there could be a number of instances where existing law would have to be reviewed. And certainly, we would provide you with the information that we do have, but I'm sure that we could collaborate with my learned friends on the other side in order to develop, hopefully, a comprehensive list. But I would make this submission if you would permit me to do so. First of all, that the effect of overruling Matthew would be certainly to cause some sort of discomfort, inconvenience, because the laws will now have to be revisited. But it would all be towards ensuring that the citizens of Trinidad and Tobago and other persons who reside here would be given the full measure of the fundamental rights and freedoms guaranteed by the Constitution. And that is a positive thing by anyone's measure. But we say further that Belize, for example, had a savings law clause which had there was a sunset clause in it. It expired after 5 years, and therefore they have not had a savings law clause since 5 years after independence. And I don't think that anyone has ever complained that something has gone awry in Belize because all existing law is now subject to review. Similarly, all of the Eastern Caribbean, they don't have existing law clauses. They do have you might say they do have built-in exceptions to their rights, to the extent that laws may depart from the fundamental rights if they are reasonably justifiable. In other words, their constitution requires the proportionality test to be applied in order to determine whether there is inconsistency with the constitution. But I would say, but again, there has not been any complaint that the legal system in the Eastern Caribbean is somehow under threat. There haven't been complaints in Barbados and Guyana either since Neves and McEwen. There hasn't been an uproar, certainly not from the governments, as to the effect of opening up existing law to scrutiny under the modification clauses. So that, Lord, I was going to make the point as well, that in Trinidad and Tobago, although the rights are declared in very broad terms, Your Lordship's board has found in the Surat decision and in the Omar Maraz decision, those rights are also subject to a proportionality test to determine whether there is violation. So that in determining whether an existing law is inconsistent with the Constitution, you would have to apply the proportionality test as well, so that there is an inbuilt buffer, as it were. So that what I'm saying, my Lord, is that the consequence of overruling Matthew is not doom and gloom, as my learned friends seem to suggest in their opening paragraphs of their submissions, but they don't really develop that later on. Yes, it is going to result, I would suspect, my Lord, in some of your previous decisions having to be revisited. But again, that would all be towards ensuring that the fundamental rights and freedoms of the Constitution are given full effect to. Again, my Lord, I'm saying that we will participate in an exercise to ensure that you have a full picture what the effect of overruling Matthew would be. Now, my Lord, if I may, there are a number of other points that I wish to address. Very briefly, I'm not too sure how we're doing with time. Possibly I can do this very quickly before the break. And it is really in relation to the positions that my learned friends have taken as to why, even if you disagree with Matthew, you should not overrule it. One of the reasons is that Matthews has been considered and followed in a number of cases. I think I dealt with that point already. Try to turn it on its head, as it were, to indicate that all that has meant is that you have had continuation of injustices in inverted commas by preserving laws which violate constitutional rights. My learned friends say that they make a number of points in their submissions from paragraphs 40 to 50 and 52 to 73, which really are an attack on the decision of the CCJ in Neves and McEwen, basically saying that the decisions are wrong. And of course, my Lord, if you are persuaded that Matthew is right, then there's no basis for overruling it, obviously. The learned friend make the point at electronic bundle 344, their paragraphs 25 to 27, that Neves is not binding on the Privy Council. Of course it is not. We're not saying that it is binding. But we do say, however, this court has already followed the jurisprudence of the CCJ in Neves and related decisions on other aspects of it, in particular in relation to the CCJ has been interpreting the right to the protection of the law. And you will see, for example, in your decision in CPASAD, which you will find at electronic bundle 1938 to 1940, your Lordships, that is a very recent decision. Your Lordship had examined the jurisprudence coming out of the Caribbean Court of Justice in relation to the protection of the law, and you accepted it. And indeed, in CPASAD, you accepted the formulation that the to the protection of the law protects you against arbitrary conduct on behalf of the state. You applied that formulation in CPSAD. And you had also accepted earlier on in the case of Maraj against the Prime Minister, this electronic bundle at 3293 to 3294, you had referred to with approval the developing jurisprudence of the court on the protection of the law. Now, in that context, learned friends rely on the observations made by Lord Hughes in the Lendor case of the danger of taking into account decisions of the European Court of Human Rights, having regard to the likely differences in criminal law and procedure. So they're therefore urging you not to, or to look upon Neves and McEwen with some skepticism, because there may be differences in the criminal law between Trinidad and Tobago and Barbados and Guyana, as the case may be. Although my learned friends have not pointed to the relevant differences that they consider might be relevant in this regard. But of course, what we are dealing with here is the mandatory death penalty and the construction of provisions of the Constitution. Again, say it is ironic that my learned friends are saying or are relying upon this argument, because the very reason why Rudal was overturned or was re-examined was because it was thought that Rudal would automatically affect Barbados. I have difficulty understanding my learned friend's argument that you're not allowed now to take into account the fact that Barbados' highest court has said that the provision should be read together to allow modification. Now, learned friends are also saying that it wasn't necessary for the CCJ in McEwen or in Neves to consider the savings law argument, that their primary concern there was the violation of the freestanding Section 11, that is the protection of the law, and so on. And somehow they seem to suggest to your lordship that the force and power of the decisions in Neves should, as a consequence, be ignored. But my lord, it is very clear that the issue as to whether the savings law clause in Barbados and in Guyana affected the case of the appellants was put frontally before the CCJ. And you see that from their decisions. If I can refer you to Neves as at electronic bundle page 662, paragraph 50. Paragraph 50, so Dennis Byron says that the Crown contends that Section 26, the Savings Law Clause, prevents Section 2 of the Offences Against the Persons Act as an existing law from being held to be in contravention of Sections 12 to 23. Crown argues that the language of the section is explicit and unambiguous. In this regard, reliance is placed on the majority position in Boyce and Joseph in the Privy Council. Their lordships held that Section 26(1) precludes the holding of anything containing or done on the authority of any existing law to be inconsistent, so that Section 1 is in relation to those sections effectively ousted. Occasion for exercising the power of modification can accordingly never arise. However, we must disagree with this proposition. Although Section 11 is not so limited by Section 26, Section 12(1), 15(1), and 18(1), which the appellants have relied on, are so limited. As such, we propose to address the 26 argument first before turning to the issue of modification. So the issue was frontally raised in Neves, as it was frontally raised in McEwen. And you'll see that at the electronic bundle 587 at paragraph 5, where the President Saunders said, second preliminary issue we must look at is extremely important. It has overarching significance, not just for this case, but for all cases where pre-independence law is alleged to be contrary to the fundamental rights laid out in our Constitution. It concerns the question whether Section 1531 is an existing law, and if it is, whether it is therefore immune from judicial scrutiny, This is a fundamental plank upon which the state defends the challenge to the constitutionality of the law. The argument is that, however, Section 153 might infringe the First to Fourth Defendant's human rights, section is nonetheless protected, part of a protected law, a law preserved and protected by a savings law. So that they identified in both cases that the issue was frontally raised. So we respectfully do not accept my learned friend's criticism on this basis. The learned friends also criticize the CCJ because they say, well, the reasoning was not as expansive or extensive as the reasoning of your lordships in Matthew and Boyce, and they criticize the reasoning as being superficial. Well, Lord, of course, when you look at the judgments, you will see that the Caribbean Court of Justice did not use up as much real estate, as it were, as your lordships did in Matthew and Boyce. The arguments were not as extensive or as long. But we respectfully submit that there really was no need for the same level of scrutiny because the arguments were well known and had already been well traversed in Matthew and Boyce. There was no point just repeating what their lordships had said. The court had made it very clear what their approach was and why it is that they were differing from your lordships in the majority in Boyce. And the reasons were that they were putting a narrow construction the savings law clause. They made that very clear. They also made it very clear that they were giving a generous construction to the Constitution. In other words, they were interpreting the Constitution as apparent from the passages that I referred you to, such a way as to ensure that the full measure of the fundamental rights and freedoms are accorded to citizens. And also their approach was to read the modification clause and the savings law clauses together. That was their approach, which also they made clear. And lastly, they made it clear that they were giving effect to international obligation. So the reasons why they departed from your lordships in Boyce were set out, even though they, as I said, they did not occupy as many pages as would have been necessary when your lordships were considering the issue in Matthew and Boyce. So we respectfully submit that the learned friends have not put forward to your lordships any sufficient justification for not overruling Matthew in the event that you think that Matthew is now to be considered as wrongly decided. My lords, my lady, those are that brings to a conclusion my part of the case. And unless you have any further questions of me, I would turn over to Mr. Fitzgerald to continue.
Thank you very much indeed, Mr. Mendes. There don't appear to be any questions for you at present, so I'll turn to Mr. Fitzgerald. Now, Mr. Fitzgerald, if you would prefer to begin at 2 o'clock, then we're quite happy to adjourn just now.
Well, my lord, shall I use the 5 minutes and just
if you please.
If your lordships will, and my lady will permit.
Yes.
Just some preliminary points. The first point I think I should deal with is the respondent's argument that the decision in Nervais and McEwen introduced no new argument. Can I just briefly summarise why we say that they do? Firstly, both Nervais and McEwen say that one must interpret the provisions of the savings clause together with the power of modification that is conferred by the Constitution Act. So the Constitution Act, at one and the same time, introduces in section 5.1 the power of modification, and in its schedule introduces the Constitution, which contains section 6. And the point made in both Nervais and in the McEwen case is that you have to take those as a whole. They also made the point, secondly, that about the need to give a narrow construction to a savings clause, and in that sense reinforce the reasoning of Lord Bingham and the minority in Matthew. And finally, they made the point about the need, wherever possible, not just where there's an ambiguity, but wherever possible, to interpret the Constitution so as to accord with international obligations. That's really in Neville Lewis, where Your Lordship's Board did reverse an earlier decision on the availability of judicial review for the prerogative of mercy. Can I just make this point? The respondents suggest that because Trinidad and Tobago is no longer submits to the Inter-American Court and is no longer a member of the Convention, that therefore the reasoning of the Inter-American Court is not binding on it. But in fact, can I just give the Court the reference, Edwards and Bahamas, which is at volume 6, tab 61, pages 2219 following, makes clear that even if a jurisdiction is only a member of the OAS, they're still bound by the American Declaration. And indeed, Edwards and Bahamas is a decision in respect to Bahamas, where they were finding that they were bound by the provisions of the American Declaration, and indeed that it was a violation of the provisions of the American Declaration to have the mandatory death penalty. And therefore, the decision of the Inter-American Court in Boyce and Barbados, which is subsequent to Matthew, because it's in 2007, which you have at volume 4, tab 44, is significant in two ways.
What's the page number, please?
It's page 16. Can I just give you the key references? It's page 1686 to 1687, my lord, where they rule that it violates the prohibition on arbitrary deprivation of life to have a mandatory death penalty, and then at paragraphs 75 to 80, which is it's later than 1687, obviously, but I'll give you but they rule that it's incompatible with the American Convention to have a savings clause at all, because it precludes you from litigating that matter.
Can I bring you, Mr. Fitzgerald, to page 430 and the point that Lord Reed made, and that is that it is envisaging, that's section 6.2, is envisaging an existing law which breaches rights, derogates from rights, being in effect perpetuated.
Well, my lord,
what's the answer to that?
Well, my answer to that, respectfully, is this, my lord. What happens is, what they're saying is, if you have, so where an enactment repeals and reenacts with modifications an existing law, and the new law is held to derogate from any fundamental rights. So supposing you have the death penalty, and then a new law is introduced which says the death penalty plus solitary confinement. The new law repeals and reenacts with modifications, i.e. the addition of solitary confinement, the existing law. And the new add-on there is held to derogate from a fundamental right guaranteed by this chapter in a manner which is to an extent to which did not previously derogate, because you didn't have solitary confinement before. Now, what you then substitute is the law that existed before. And that's just a general provision that where you go back to the law before. But it doesn't say, and you go back to the law before irrespective of whether it violates rights or not. Because it says you go back to the law before without the derogations. So, as my friend Mr. Mendes said, that leaves...
Well, perhaps we can return to this at 2 o'clock, but I wonder why you say you go back to the existing law without derogations under Section 6.2.
Well, because you go back to it, it says, substituted for such provision as are held to derogate from the fundamental right in a manner in which or an extent to which the existing law did not previously derogate from the right.
Yes. So the additional derogations are effectively...
Yes, they're removed.
But the existing derogations, well...
Well,
Lord Stevens' question remains.
my Lord, the simple example is this: that we accept that the death penalty cannot be voided. In other words, you can't have a sensible reading of the Offences Against the Person Act, modifying it to exclude the death penalty. It wouldn't, but we don't accept. So you just go back to the death penalty, but you can have the death penalty which is mandatory, or you can have the death penalty which is discretionary. But it
only derogates from rights by virtue of the fact that it's mandatory. And if you go back to a mandatory death penalty, then it continues to derogate from the rights.
Well, my Lord, it's to the extent that it derogates in a way that cannot be sorted out by modification rather than invalidation. In other words, my Lord, there are certain statutory provisions which simply can't be saved by the process of modification. That is the presumption of Beccles and Delamore, and of all the cases, and indeed it's.
So this should be confined, therefore, to invalid laws.
Yes.
And nothing more than that.
Yes, because there are certain things where you simply can't save them by modification, and those laws cannot be invalidated and therefore remain. So you couldn't, for example, remove the death penalty, but we know that by modification, because it's been done in every other jurisdiction, you can remove the mandatory death penalty. But there's a whole case law, as my learned friend Mr. Mendes made clear, a whole case law that precedes the introduction of the prohibition on invalidation. And what invalidation meant was you invalidate the whole law. And what those cases like Beccles and Delamore showed was you can do an awful lot by modification, but the thing you cannot do is to invalidate. So the law, which cannot be invalidated, remains, despite the fact that it derogates from fundamental rights. And my Lord, the death penalty could be open to challenge itself. I mean, there's case law I can show you on that. But in fact, you can't do that because of Section 6 says you can't invalidate the law as a whole. So, I mean, the kind of challenge that's been made in the European Convention to the death penalty itself would just simply not be open because it would invalidate the whole law. There'd be no sense in the law. Why does it say death penalty at all? And so what all those cases show, and what Lord Bingham carefully showed, is if you ask yourself, why are they talking about invalidation? It's because the language of invalidation had become a term of art to describe something which you did when you couldn't modify. If you can modify, you modify. If you can't modify, you can invalidate. The one thing you can't do is to invalidate. And with great respect to Lord Hoffman, he was constitutionally illiterate in not recognising that there was a historical background to that distinction between modification on the one hand and invalidation on the other hand, which explained, with domestic case law of Trinidad itself, what the meaning of the word invalidate is. It means wholesale invalidation. You can't rescue the act. You can't produce a sensible legislative scheme, that's the language that's used in some of the cases, by means of modification. So what you then have to do is not invalidate. And of course, one of the ironies of this is, if you amend an act, as they did in Jamaica, in order to try to improve things and introduce different types of death penalty, different types of murder attracting the death penalty, if you try to improve things like that, it becomes susceptible to challenge because it's not an existing law any longer. It's a new law. Sorry, my Lord, I'm going way beyond.
Yes, I think
Forgive me, my Lord.
we will hear you further at 2 o'clock.
Yes.